Big wins for the White House this week at the Supreme Court. In a 6-3 decision upholding the Obamacare subsidies, Chief Justice John Roberts sided with the majority, earning him some criticism from conservative ranks. And then there was Friday's ruling legalizing same-sex marriage in all 50 states. And the term's not over just yet. Joining me now to take a closer look at the big decisions by the court this week and what's still left, Ryan Anderson, Senior Research Fellow at the Heritage Foundation, and Brianne Gorod is the Appellate Counsel at the Constitutional Accountability Center. Good to see both of you today.
Thanks for having us.
Brianne, I want to start with you about those Obamacare subsidies, so critical to keeping the law functioning as it is now. A big win for the White House.
Yeah, no, I mean, it was great. And it was great primarily because a majority of the Supreme Court justices did exactly what judges are supposed to do. They looked at the text of the law as a whole, and they applied it exactly as Congress wrote it. I mean, the challengers to the law wanted the justices to look at just 4 words and ignore the rest of the 900-page statute. And that's just never the way that members of the court are supposed to interpret laws.
Yeah, and the chief took a lot of heat for that because he authored that opinion, and he said, I find that phrase to be ambiguous. He talked about it being taken out of context and looking at the larger picture. So, Ryan, you think he got it right or wrong?
I think he got it wrong. I mean, I think established by the states means established by the states, not established by the states or the federal government. And not only is the text clear here, but looking at the larger intention, we have Jonathan Gruber several times caught on camera saying precisely that this was intended to be a way of forcing the states into the exchanges. When the states chose not to, this law should have been struck down.
Well, and a lot of people ask me because, you know, it's such a wonky thing about the way that the court works, but I have a lot of people asking me, why wasn't, you know, Gruber in play? Why wasn't that part of what they considered? Why didn't they talk about that at the arguments? But, of course, that wasn't part of the record.
Brianne. It wasn't part of the record, and what's important to remember is that, you know, Jonathan Gruber didn't write this law. The people who did write the law filed an amicus brief, a friend of the court brief, that made clear that that was never the way the law was supposed to operate, and it was never the way the law was understood to operate. When you look at the text of the law as a whole, which is what courts always do, it's very clear that those 4 words do not tell the whole story. The text of the law as a whole makes clear that tax credits are supposed to be available nationwide. As you said, it's the only way the law can operate as it was supposed to operate.
And at the end of the day, that's where the chief came to in writing, saying that his assumption is that what Congress intended was to make sure that health care insurance was available more broadly, and to find otherwise would gut the intention, he said, of Congress. So some disagree, some agree with that, but it is the official decision. All right, the following day, of course, we got the 5-4 ruling authored by Justice Kennedy. We expected he would author it, and he's sort of the swing vote here, siding with the 4 members of the court that are widely, you know, classified as the left, although I know the justices don't like to be put into those categories. But it was a sweeping opinion. We thought he might go more narrowly and defining this, but he said fundamental constitutional right that same-sex couples are to be treated exactly like opposite-sex couples, and that he's often talked about the dignity of these couples, their families, the kids they adopt. It seemed like that was that resonated with him. Of course, 4 scathing dissents who said essentially, Ryan, that he made law where it wasn't intended to be found.
I think the 4 dissents got the case exactly right. That anyone who cares about constitutional law, the rule of law, democratic self-government, or marriage has to be disappointed by what the majority did in this case. Justice Kennedy just redefined marriage not based on anything in the Constitution, but based upon Justice Kennedy's philosophy of what marriage is. The Constitution is silent on what marriage is, and that's why the 4 dissenting justices said we, the people, have to decide whether marriage is a gendered institution, a union of a man and a woman, or a genderless institution, a union of any 2 consenting adults. But judges don't have any greater insight into that question, and the Constitution certainly doesn't say anything to that question. And so it was judicial activism for the court to redefine marriage in all 50 states.
Brianne, a number of the dissenting justices also brought up the idea that this should have played out as a states' rights issue, and they thought it actually harms the overall cause for this to be done in such sweeping fashion. Justice Ginsburg has sort of criticized Roe for doing something so broadly at first. Do you think it would have been helpful for those who are on either side of this debate to let it play out at the state level?
Well, I think that just fundamentally misunderstands the way our constitutional democracy works. I mean, our Constitution is the supreme law of the land, and we put certain fundamental rights into the Constitution precisely so we don't have to ask our neighbors whether it's okay for us to exercise them. The Supreme Court justices did exactly what they're supposed to do. They looked at the text and the history of the Constitution, and that makes clear that there should be marriage equality. And, you know, it's worth noting, obviously people will disagree. The majority of the court recognize that. People can continue to disagree, and they continue to voice that disagreement. But that disagreement can't trump the fundamental right to equality and fundamental right to due process that's in our national charter.
And Justice Kennedy talked, and we're quickly because we're almost out of time, but Justice Kennedy talked about the fact that there are those with concerns about religious objections. He said those should be respected. We should continue to have this conversation. But a number of the dissenters saying they think that this is going to now mean that should you voice any support for traditional marriage in the public square, you're going to be deemed a bigot, and you may risk your job and your livelihood and all kinds of things.
And again, the dissent's got it right. We're already seeing Catholic charity adoption agencies being forced to shut down. We've seen the baker, the florist, the photographer. The question here is that the majority opinion said religious people will have the freedom to teach and to preach. And Chief Justice Roberts correctly says it's the free exercise of religion that our Constitution protects, and that they were silent about that. Will we have the freedom to live out our lives in accordance with our beliefs in the public square Monday through Saturday, not just Sunday morning?
I think we all agree that's probably going to be the next part of this debate. And by the way, there are still decisions tomorrow. We'll be out there to find out ruling on the EPA, the death penalty, and another one on redistricting for voting as well. So term not over just yet, but thanks for joining us for an overview.
Thanks.